Now, three speakers finish their presentations. Then we will listen to the discussants. Our first discussant is Mr. Matthias Füracker. Mr. Füracker joined the International Tribunal for the Law of the Sea as a legal officer in 2008 after serving German government as a lawyer and is currently working for the court as head of legal office. Mr. Füracker, you have floor.
Yeah, thank you, Professor Lee, for giving me the floor. And I also wish to thank the organizers for inviting me to this conference and for all their work in preparing this event under very difficult circumstances, as we all know. I'd like to congratulate first the three panelists for their excellent and very interesting statements made today. I think the issues covered by the panelists were very much complementing each other and provided a very good and coherent overview of important issues. In my brief comments, I will try to highlight some of those issues that were addressed in the statements and that I consider particularly pertinent, and I will try to build on this to refer to a few further issues that might merit a debate in the context of this panel. And I will address the statements in the order of their presentation. That's why I will start with the statement of Judge Heidar. Judge Heidar gave us a comprehensive overview of what the tribunal has contributed so far to the international law on the protection of the marine environment. In fact, numerous cases that were dealt with by the tribunal in the past did have environmental implications, and they gave the tribunal several occasions to shed light on some key issues, and Judge Heidar referred here in particular to issues such as the precautionary approach, sorry, environmental impact assessments, as well as the duty to cooperate. It became clear from this paper, in my view, to which extent the tribunal shaped and developed the convention's rules concerning the protection of the marine environment, rules which Judge Heidar mentioned and Professor Nguyen just repeated, in fact reflect the state of the art of the 1970s. And in this connection, it is of course important that the tribunal has shown this willingness to interpret those rules consistently with contemporary state of environmental law. What is also interesting is that the tribunal's contributions to marine environmental law were so far made in proceedings on provisional measures and advisory proceedings. And now, without diminishing the importance of these procedures, of course, which remain very important, for example, in environmental impact assessment issues. But nevertheless, we could maybe ask ourselves the question, what else can we expect in the future in terms of cases brought before the tribunal in the field of environmental law? One question could be, will we see more cases on the merits, contentious cases on the merits, for example, for reparation, etc. Such cases might emerge, among others, from the tribunal's 2015 advisory opinion concerning IUU fishing. The tribunal has there opened a door for holding a flag state responsible for its failure to take necessary measures to ensure that vessels sailing under its flag do not engage in IUU fishing. Another potential origin of cases could be deep seabed mining. Once commercial exploitation of seabed minerals will start, disputes between the relevant actors are likely to emerge. And given the potential impact of seabed mining on the marine environment, it seems quite possible that some of those disputes will have environmental implications. And of course, as everyone here is aware, states are currently negotiating a new legal instrument concerning biodiversity in areas beyond a national jurisdiction. Several aspects of this new legal instruments are still, of course, under debate, and this includes how the dispute settlement system of this instrument might look like and which the tribunal could play therein. Nevertheless, we might, if we have time, and we might exchange views on this future instrument and the prospects for dispute settlement that it offers. I will now turn to Mr. Lowenstein's statement. he gave us an example of sources of disputes that might find their way to international courts and tribunals even more frequently in the future, namely disputes dealing with alleged violations of due diligence obligations. He highlighted in particular the importance of environmental impact assessments and their role in the exercise of due diligence. And he also told us about the distinction between the determination of whether an environmental impact assessment needs to be conducted, the screening, and what its scope and content would be, the scoping. In this connection, Mr. Lowenstein highlighted that what is required under a due diligence obligation, including with regard to environmental impact assessments, cannot be determined abstractly for each and every situation, but needs to take account of the concrete circumstances. He also referred to the pulp mills case and the ICJ's finding therein that it is for each state to determine the specific content of the environmental impact assessment required in each case. And at the same time, he told us that this does not mean that states have complete discretion in that question. Another important point in Mr. Lowenstein's statement, in my view, was his emphasis on the role of scientific evidence in possible cases before international courts or tribunals dealing with environmental impact assessments. Among other things, he made clear that frequently scientific questions are highly contentious between the parties to such cases, and therefore the traditional approach, as he called it, that courts try to rely on uncontested scientific evidence might less and less be possible. So I think, again, there are some interesting questions that come to mind with regard to this statement. One is taking into account this variability of due diligence obligations and the not complete but seemingly quite large discretion that states enjoy. One may ask whether international courts and tribunal will be able to establish, nevertheless, a certain degree of objectivity and predictability in this respect, if this is desirable at all. And another point, in light of Mr. Lowenstein's remarks on the importance of scientific evidence, we might also discuss what the future practice of international courts and tribunals with regard to the assessment of such evidence might be. We are aware that in the past, courts and tribunals have had a certain reluctance to rely on expert evidence, for example. There is the assumption that this might change. And so the question is, will courts and tribunals make more use of experts? And how will they do that? And one may note, for example, in this respect, that the procedural law of the tribunal provides for different possibilities for appointment of experts. Now, I turn to Professor Nguyen's statement and make a few remarks on that. She dealt with some highly important questions of jurisdiction and applicable law in judicial and arbitral proceedings instituted under the law of the Sea Convention. In her statement, she emphasized the need on the one side to find a holistic approach to an environmental dispute submitted to an international court or tribunal. On the other side, of course, such court or tribunal must respect the limits of its jurisdiction. Now, Professor Nguyen noted, and I'm glad to hear that she comes to the conclusion that courts and tribunals generally stay within their jurisdiction and that there is no a conflation of jurisdiction and applicable law, so that they adhere to this idea of the separation of the concepts and of jurisdiction and applicable law. She also set out that there are different means available to courts and tribunals once they have established the jurisdiction to broaden the body of law they can apply to adjudicate a dispute, including by interpreting provisions of UNCLOS in light of the provisions of other international treaties, and she has distinguished between internal and external mechanisms in this respect. Now, 2 or 3 remarks on that or questions. As regards the jurisdictional limits, I of course share this view that international courts and tribunals must respect the limits of their jurisdiction, in particular so when they are operating in a system of compulsory dispute settlement that allows for the unilateral submission of cases to a tribunal. There is, of course, also the possibility for states to submit a case on the basis of a special agreement. So in a joint effort to do so, and one might say that, of course, looking at the history, this has been the classical way of how international dispute settlement came about. So I wonder whether Professor Nguyen thinks there are still chances that states resort to this more classical way of instituting interstate litigation, and whether she would agree that under such an agreement, the jurisdiction of a court or tribunal might, of course, be much broader. Now, as regards the issue of applicable law, I also agree that, in principle, a holistic approach to the interpretation of the Law of the Sea Convention is desirable, and maybe even more so in the field of international environmental law, which is quite a fragmented area of the law. And so Professor Nguyen also stressed that this might actually be a way to overcome fragmentation, to defragmentize. She also mentioned that there might, of course, be issues when applying international treaties or when seeking inspiration from international treaties for the interpretation of UNCLOS, if the states that are parties to a dispute are not at the same time parties to these international treaties. And indeed, I think that raises interesting questions to reflect about. Something that came to my mind might seem as a minor point, but actually environmental law is also particularly shaped by what is called, maybe in an unfortunate term, soft law. So I wonder what role could there be for soft law instruments to be applied in this context, and how could they influence the interpretation of the convention? And finally, if there is time, we might actually broaden a bit the question of jurisdiction, go beyond what we discussed here, jurisdiction ratione materiae, and also speak maybe a bit more about jurisdiction ratione personae. Professor Nguyen mentioned Article 192 and its important role. Assuming that it is a provision that has erga omnes effect, we might, of course, come to the question, who would be a state that has standing before the tribunal to bring a case about its violation? Might this also be a state that is not directly affected by a certain harmful activity? And so could this then become a form of public interest litigation, which in national law, of course, we see a lot, in particular in the area of environmental law. So this would be my remarks, a bit more than 10 minutes. I'm sorry for that. Thank you.
Thank you for your thoughtful comment. Now, I will give opportunity to respond to the questions after the second discussant. I will introduce our second discussant, Dr. Young-Kil. Dr. Park is the director of the Law of the Sea Research Center at Korean Maritime Institute. Dr. Park, floor is yours.
Thank you, Chairman. It is my great pleasure and honor to participate in this well-known conference as your discussant. I would like to express my sincere thanks to the Ministry of Foreign Affairs of Korea and the Korean Society of International Law for the kind invitation. Today, international community has been increasingly recognizing the importance of the protection and preservation of the marine environment. A good example today will be the issue of marine plastic debris. It seems that international courts also take active position in dealing with the matters of the marine environment in recent cases. Today, the three speakers have very well addressed marine environment issues in terms of the dispute settlement mechanism under the Law of the Sea Convention. The presentations are very helpful to understand not only general but also very specific issues concerning dispute settlement about the marine environment. So I have no objection to the contents of the presentations. Thus, instead of comment on their presentations, I want to raise 3 questions on specific issues. My first and second questions go to Judge Tomas Heidar. And the first question is about the possibility of actio popularis. Article 192 of the Law of the Sea Convention provides that states have an obligation to protect and preserve the marine environment. It is to preserve the common interests of the community of states, as mentioned in the introduction of the presentation paper by Judge Heidar. Also in paragraph 927 of the South China Sea Arbitration Award, the Tribunal noted that because the environmental obligation in Part 12 applied to states, irrespective of where the alleged harmful activities took place, its jurisdiction is not dependent on the question of sovereignty of any particular feature. On the prior determination of the states of any maritime feature, on the existence of an entitlement by China or the Philippines to an exclusive economic zone in the area, or on the prior delimitation of any overlapping entitlements. In this regard, my question is, suppose a state conducts activities such as building artificial islands in its EEZ or continental shelf that may incur possible damage to the marine environment in general. Can any other state bring this case to international courts, even though the activities do not directly impact the state? This is my first question. And my second question is related to Article 83, paragraph 3 of the Law of the Sea Convention, and the case between Ghana and Cote d'Ivoire on the maritime delimitation. Ghana took hydrocarbon activities in the area of overlapping jurisdiction. However, the area finally belonged to its place through the delimitation in Ghana and Cote d'Ivoire case. Special Chamber of the ICLS found that the activities of Ghana didn't take place in the Cote d'Ivoire's maritime area. Therefore, it is impossible to state that Ghana has undertaken activities which have jeopardized or hampered the conclusion of an agreement as envisaged by Article 83, paragraph 3 of the Convention. My question is that if a country tries to build installation or structures in the EEZ or a continental shelf for the marine scientific research in the area of overlapping jurisdiction, then do you think such activity can violate Article 83, paragraph 3, or articles relating to the protection of marine environment of the Law of this Convention? My third question goes to Professor Nguyen. My question is about the application of other rules of international law. As you explained, if the relevant states of the dispute are parties to the agreements, the Tribunal can apply applicable agreements to the case in addition to the Law of the Convention. My question is that if both parties not to apply the relevant agreements in the case, can the Tribunal still maintains the discretion to apply the agreements in the case? This is my last question. And thank you very much for the kind attention. Thank you.
I appreciate your insightful comment and questions. Now, each speaker can respond to the comment and questions which was delivered by were delivered by two discussants. At first, I will turn it over to Judge Heidar.
Thank you very much. Can you hear me? Yes. So I would really like to thank all my colleagues for very nice presentations and also the commentators, very good questions. I would like to touch upon things that have been mentioned by other colleagues, starting with Andy Lowenstein. Very correctly was emphasizing the importance of scientific experts in environmental cases that can be quite complex. I think the tribunal has the possibility to arrange for an expert opinion and to designate an expert, and this is in line with Article 82 of the rules of the tribunal. And this is based on a rule by the ICJ. The tribunal has never done this, so the tradition has been to rely on evidence provided by the parties, which is often quite at dispute. But there has been an interesting development in the ICJ. Typically, ICJ would not, obtain an expert opinion, but there seems to be a change of a positive change there, and I think the most recent one is in the case Congo-Uganda, where the ICJ decided to obtain an expert opinion to evaluate, among other things, loss of natural resources, and they have also appointed two experts to make that expert opinion. And there is also the option, of course, which is contained in Article 289 of the Convention, which has never been applied, but I think has a lot of promise. And this is in the case of the tribunal, it would select, in consultation with the parties, two or more scientific or technical experts. And in this case, they would sit with the tribunal and participate in the deliberations, but without the right to vote. I think this provision holds a lot of promise in complicated cases in the future. Andy Lowenstein also mentioned the 2015 advisory opinion on IUU fishing, and this was also mentioned in more detail by Professor Nguyen. And so this is a kind of a favorite case of mine, although I was not on the tribunal when this advisory opinion was rendered. But for me, this is a very important opinion, and this also touches upon a question by Mr. Matthias Füracker, which is about the possibilities of contentious cases in the future. What might they be? And I believe this 2015 advisory opinion is really a guideline for coastal states to assess whether a flag state has lived up to, complied with the due diligence obligations prescribed in the advisory opinion in order to prevent vessels flying its flag from engaging in IUU fishing in the EEZs of coastal states. So I believe, and of course, if the answer is that they haven't, then of course it is up to the coastal state to bring a case, a contentious case, for example, to the tribunal. And so I have to say, given the importance of the 2015 advisory opinion, I'm rather surprised that such a case has not appeared. I think the advisory opinion provides a good basis for the assessment of a situation, such a situation. Now, Professor Nguyen referred to the separate opinion of Judge Peck. And whenever I lecture on this advisory opinion, which I do quite often, I always include a description of the advisory opinion of Judge Peck and also of Judge Nadaye, because the philosophy of their separate opinions was that one should not only take into account in assessing these obligations, flag state obligations, the Law of the Sea Convention, but also the subsequent developments, as was described by Professor Nguyen. And I have to say that I agree with those separate opinions to that extent. I think it was, I think the reason why the majority decided to stick to UNCLOS and not go beyond UNCLOS was the fact that this was the first advisory opinion in the history of the tribunal. It was a bit contentious. There were some states that made submissions holding that there was no basis for such advisory jurisdiction. So I think the tribunal decided, one, to keep the scope of application strictly to the exclusive economic zones of the 7 West African coastal states, and secondly, to limit it to UNCLOS and not look directly at post-1982 developments, even though, of course, it was particularly in the 90s, that these instruments were negotiated that include very detailed flag state obligations with respect to fisheries. Whereas in UNCLOS, there is none. There is no obligation, flag state obligation with respect to IUU fishing in the convention. So I do agree with as Judge Peck referred to it as a rule of reference to include those post developments into the opinion. Professor Nguyen referred to Article 331, Paragraph 3 of the Vienna Convention, Law of Treaties. I'm not absolutely certain that it applies strictly, because the problem here is that you have UNCLOS, which is quite widely ratified, and then you have other instruments, such as the UN Fisheries Agreement, which is much less ratified, so it's not the same parties. So that might cause a problem for the direct application of Article 31, Paragraph 3, but I think the philosophy is there anyway. Now, with respect to the future, Mr. Füracker referred to what could you expect in the future. As I say, I would not be surprised if there were an IUU fishing case, a contentious case on the merits. I also think that quite obviously deep seabed mining will have a lot of environmental implications. So I simply assume that there will be some disagreements in the future because of environmental impacts of deep seabed mining. And I could see that the deep seabed chamber of the tribunal will have a role to play there. The BBNJ agreement, of course, will expand on environmental law, in particular MPAs and EIAs, conservation tools, but also in terms of a possible special role for the tribunal. I think that is quite possible. Now, this is a new agreement. When the convention was negotiated in the 70s and early 80s, obviously the tribunal was not there. It was only established with the convention, started only in 96. So it was natural, I think, in the 1982 convention to have the advisory, the arbitral tribunal, Annex 7, as the default mechanism. I think if states were now to negotiate, and they would probably give that role to the specialized Law of the Sea Tribunal that is in Hamburg. So I think it is possible that in the BBNJ negotiations, the parties will give some special role to the tribunal, either making it the default mechanism or make explicit an advisory jurisdiction for the tribunal on any issues that may arise under the new agreement. And perhaps it could be the conference of the parties that will probably be established that would have the role then of referring requests for advisory opinions to the tribunal. And then finally, turning to Dr. Park's questions, it is kind of the privilege of being a judge that you sometimes can kind of excuse yourself from answering questions, and I think that would apply to the second question. You have to be careful when you're a judge what you say officially, and I think I might be going into an interpretation there. The question regarding Ghana, Cote d'Ivoire. that might hit me in the future. So I think I better be silent on that one. When it comes to actio popularis, the first question, I have thought about this in the context of the continental shelf. You know, when you have a question on whether a coastal state has gone beyond. I mean, if there is a, let's say there is a, well, if there is a question whether the coastal state has, respected, complied with the substantive provisions of Article 76 on the outer limits of the continental shelf. And let's say also there is a question whether the coastal state has gone beyond the recommendations of the CLCS. As you know, if the coastal state establishes the boundary on the basis of the recommendations of the Commission, then those outer limits are final and binding. But what happens if the coastal state goes beyond that? And irrespective of that, what happens if there is inconsistency with the substantive provisions of Article 76? So I think the question there arises: who can take legal action if there is any question about that? And I think it is generally recognized that the International Seabed Authority does not have the locus standi to do so, even though it has a role with the area. And also the Commission on Limits of the Continental Shelf certainly does not have any standing. So I think the question is which states could do so. And I think there is an argument that any state party, at least to the convention, could do so, because they all have an invested right in the common heritage of mankind, that is beyond the area beyond the continental shelf. So at least in that, so I think there are some possibilities for what we could call actio popularis, in also when it comes to other issues like relating to the marine environment. So I'm sorry I took so long, but there were so many interesting issues and questions that came up in this very interesting panel that we have. Thank you. Thank you
for your thoughtful answers. I'm very sorry not to give enough time. Now, Mr. Lowenstein, please give your answer.
Thank you very much for these really interesting questions. With respect to the first question concerning the abstract nature of the due diligence obligation and how that relates to what one might call an objective or goal of having a degree of predictability, and one might even extend it to say guidance to states or project proponents as to what concretely they are obligated to do and when they're obligated to do it. There's always an inherent tension between those sort of competing objectives, and some legal regimes tend towards the predictability side of things. The ESPO Convention, I think, is a good example, where it lists certain types of projects that are required to have EIA. Other legal regimes don't, and it's based more on the significance and likelihood that the project will have adverse environmental impacts. I think whether there should be this sort of heightened degree of predictability depends on whether you're talking about screening for whether an EIA is required, or whether you're talking about what the content of an EIA must include. My sense is that the default is now becoming, essentially with respect to screening, that any project of any kind of meaningful size or scope is required to have an EIA. And if a project proponent or a state is going to forego having EIA, it better have a very good reason. And sometimes those reasons exist. So in the companion cases heard by the ICJ involving the San Juan River, one of the issues that the court confronted was whether Nicaragua was obligated to have conducted an EIA with respect to a dredging project it carried out on the river, which Costa Rica argued would likely have effects on water flow to a Costa Rican river that branched off from the main river. And ultimately, the court decided that the EIA was not required, but that was really based on a very robust showing by Nicaragua that there would be no adverse impacts to Costa Rica. And in fact, in the context of the experts for both parties ultimately agreeing that the diversion of flow would be minimal. Contrast that with the court's determination that Costa Rica was obligated to carry out an EIA with respect to its highway construction project sited in fairly close proximity to the San Juan River. And I think you start to get the sense that you really do need robust evidence that there will not be adverse impacts in order to excuse the EIA obligation. When it comes to issues of scope and content of the EIA, I think it's quite difficult to have a sort of a preset determination as to what is required. These projects are so sui generis that it's hard to have the type of predetermined requirements. It's really, I think, fact dependent and ultimately comes down to what the project is, where it's located, what the receiving environment is going to be like, and that then determines what the EIA must undertake, and then ultimately what actions must be undertaken as a result of the determinations made in the context of the EIA. Turning to the second question about the treatment of scientific evidence by international courts and tribunals, I do think that experts appointed by courts or tribunals have an important role. But I also think that one of the sort of underappreciated functions of counsel is to not just obviously advocate on behalf of the state councils representing, but also just to fundamentally assist the court or tribunal in evaluating the evidence that's before that court or tribunal. And I believe quite strongly that what counsel should do is help to distill complex evidence and to elucidate where the areas of divergence are, which are not always necessarily clear from sort of undigested expert evidence. And so it's really the function of counsel to help the court or tribunal understand where there are differences and explain why one view should prevail when the other should not. So I think independent experts have an important role to play, but also that that counsel sort of function within the judicial system also has an important role to play as well. I'll just make one final comment in response to Judge Heidar's comments relating to the 2015 advisory opinion. I completely agree. I think that it's almost inevitable that there will be an IUU fishing case. The invitation seems quite clear, and the content of the obligation that's set out in the advisory opinion is so clear and so strong that I think it's inevitable that a coastal state will accept the invitation as they should.
Iron. Mr. Lowenstein?
Yes. Yes.
Thanks for your comment. Now we will listen to the Professor Nguyen's response. Professor Nguyen, you have floor.
Yeah, thank you very much, Mr. Chair. I thank all my esteemed panelists for their presentations and remarks, and particularly to the two discussants for very interesting questions. In the interest of time, I will try to keep my answers short and brief. Mr. Füracker had three questions slash comments for my presentation. Thank you very much. The first one relates to jurisdictional limits when it comes to special agreements. Is there a limit there, or the jurisdictional restrictions under 2881, would it apply then? That's my understanding of the question. I think this is a very interesting point. I actually had not thought of that when I was writing or preparing this presentation. In the framework of Part 15, I think, and particularly focusing on ICLS and Annex 7 Arbitral Tribunal here, I think when the parties decide to conclude a special agreement, then I think there's a more leeway there for the jurisdiction of the tribunal to be extended. And I'm looking at particularly Article 21 of the statute of the tribunal, which says that the tribunal has jurisdiction on matters specifically provided for in any other agreements, which confers jurisdiction to the tribunal. So I think this might be the legal basis for the parties to decide to confer broader jurisdiction to the tribunal if they so wish. And similarly for the Annex 7 arbitral tribunals, I think when it comes to arbitral tribunals, the parties also have the discretion there to decide the matters or the issues that the tribunal would look into. So I think there is certainly means there or ways there or possibilities there by virtue of special agreements to expand the jurisdiction of the tribunals beyond the confines of Article 288, paragraph 1. In terms of the impact of soft law instruments on applicable law, I think this is also fascinating. I think the nature of soft law instruments is that they impact states' behavior not by virtue of being binding or otherwise. So in the same manner, the soft law instrument could affect applicable law in dispute settlement similarly. So for example, for the rule of reference, for a norm or an external norm and rule to be incorporated into UNCLOS by virtue of the rule of reference, it does not matter much whether the rules of those rules and norms are found in conventions or treaties that are already binding on the parties or not, but whether or not they reach the threshold of generally accepted rules and standards. And I think a lot of soft law instruments do provide norms that have this impact or can reach this threshold. So then the soft law instruments could play a role in applicable law through the rule of reference, for example. Otherwise, it also, by virtue of the impact on the conduct or the behavior of states in particular legal issues, soft law instruments could also be taken into account as applicable law through subsequent conduct under Article 31(3)(b). Now, of course, there is a question of whether the subsequent conduct was the conduct to establish an agreement on the interpretation or application of the convention. There is that condition to be met, but I think there is an avenue there for soft law instruments to have an impact. Last but not least, a question on erga omnes, and I think this touches upon Dr. Pak's question to Judge Heidar as well. Very interesting. I think we all know that there's now a fascinating case before the ICJ between Gambia and Myanmar based on this notion of erga omnes, but particularly in that case, I think erga omnes ex parte, so a little bit more restricted than the concept of erga omnes in general. So we do see, I think, this trend or this issue of actio popularis now becoming more popular or being talked about more often. Yeah, I think Article 192, as Dr. Pak correctly identified, and Judge Heidar also mentioned the issue of the outer continental shelf, the establishment of the outer limit. It could well be an issue that will be faced by UNCLOS tribunals. But otherwise, I was just thinking, there's an idea that came to my mind was in terms to not be faced with this question of standing, and when it does come to the protection of the environment, perhaps to not be tied down by this question of admissibility, the avenue of asking advisory opinion could also be considered. Turning to Dr. Park's question, it is a difficult situation if the parties to the case are not parties to these external sources to which the tribunal refers. What happens? I think the first one is, I think there should be a distinguish between interpreting UNCLOS provisions by reference to other sources and deciding disputes relating to other sources. So, for example, in the South China Sea case, the arbitral tribunal made it very clear that they do not have jurisdiction to consider violations of the CBD, but they do have the jurisdiction by virtue of applicable law to look at CBD to interpret UNCLOS provisions. So that would be the first point to make. And then the second point would be, yes, I think tribunals, as I said in my presentation, would have to be careful to decide the extent to which they stretch applicable law to bring in external sources to decide UNCLOS disputes, because this might meet backlash from states, and states feel like they are being imposed obligations to which they otherwise have not consented. So this is something that the tribunals would have to bear in mind and tread carefully. And lastly, turning to Judge Heidar's comment on the advisory opinion, I fully take your point that Article 31(3) of the VCLT might not squarely be the legal basis for reference to subsequent agreements. And that is why in my presentation I placed a question mark there. But I think there is a lot of nuance to this analysis, which I include in the monograph that I'm now developing. So it's not a straightforward, and I don't think Article 31(3) is a panacea for every single reference to external sources. So I fully take your point there, and there is nuance to that analysis. Right, so I will conclude my remarks there, and thank you all again for your very insightful comments.
Many thanks for your excellent comment. Finally, we come to the end of this session. I would like to express my deep appreciation to all the speakers and discussants once again for their informative and insightful talks. Many thanks also go to the audience on the floor and in the internet for your participation and attention. As we all know well, there are several legal issues, including institutional issues, procedural and jurisdictional, for the peaceful settlement of environmental disputes. Today's discussion focused largely on the applicable law only. So I do hope we can have another forum to discuss the remaining issues in the near future. Now I close the session 5. Thank you very much.
Thank you very much, Professor Lee Jae-Gon, for your wonderful moderation of session 5. Please give a big hand to our chair and all session 5 panelists. Distinguished guests, speakers, and discussants, participants, ladies and gentlemen, this brings us to the close of this year's conference, the 5th International Conference on the Law of the Sea. During the past 2 days, we have meticulously and extensively explored the overarching topic of regional cooperation in marine environmental protection under the UNCLOS regime. We had 5 main sessions in which 15 speakers, 5 moderators, and 10 discussants exchanging their knowledge, information, insights, and ideas on this topic. Thank you for sharing your expertise and hard work. And thank you to all participants who joined in person and virtually for paying your attention, for the ideas put forward by the most relevant scholars and experts studying and practicing in this field. I'm sure this year's conference has added another productive and valuable page to the annual international conference on the law of the sea, hosted by the Ministry of Foreign Affairs of the Republic of Korea and organized by the International Tribunal for the Law of the Sea and the Korean Society of International Law. Until we meet again for next year's conference, hopefully in person and in Seoul, Korea, please stay healthy and farewell. Thank you.